Good day, friends. Today we will discuss valuation of licensed property under Indian Easement Act 1882. So here we will discuss what is the difference between licensed property and leasehold property, how the valuation of licensed property is to be carried out. So this is an important topic from income approach method. So first we will discuss what is license. So license, it is under Indian Easement Act 1882. So first thing you must remember, it is under Indian Easement Act 1882. It says a licensed property refers to a property where the owner is called a licensor, grants another person, the person to whom the license is granted is called licensee, the right to use a property for a specific purpose. This is important thing here. It is for a specific purpose. It cannot be used for any other purpose. This permission is personal and does not transfer any ownership. In this case, no ownership interest is transferred to the licensee. So, for examples of license are parking space. So, let us suppose a property owners allow a neighbor to park their car in the driveway. So, this permission is license because the neighbor does not gain any ownership right over the driveway. He just can park his car in the driveway. Then another example is vendor stall. So a shopping mall owner grants a vendor the right to set up a stall in the mall for a limited period, maybe for 1 month, 2 months, or for a year. So the vendor, what the vendor here can use, he can use the space, but does not own any part in the mall. So these two are another type of license is temporary access. So a landowner permits a farmer to cross their land to reach their own field. So this is a license to use the land for access, but the farmer does not gain any right to the land itself. So this is what the license is. So, but many times this act or this license under this act, it is used by the land owners or landlords to for tenanting their property, for renting their property. So why they do so? So in order to get relief from the Rent Control Act and to avoid complication in tenancy rights, the properties are sometimes given on lease and license basis. So the compensation received by the licensor under such arrangement is usually substantial, and in many cases it may include the higher charges for furniture, fixtures, service charges, or special amenities, etc. So basically, to avoid the complications of Rent Control Act, many times the landlords give their property, instead of giving them this property on rent, they give it on license basis, lease and license basis under the Indian Easement Act 1882. So, so what? Who is licensor and who is licensee? The person who has the title to grant license is called licensor, and to whom the license is granted is known as licensee. So next we will discuss essentials of license. So first thing to remember, license does not confer ownership of real estate. Rather, it simply creates personal rights and obligation. As a result, it cannot be assigned. Second, a license is typically revocable. This is important thing. License is revocable, where lease is not revocable at the whim of grantor, because it may be given expressly or impliedly, not through unfavorable use or any other ways. Then a license simply makes an action that would have been illegal otherwise permissible. It does not grant ownership rights to the actual property on or over which the action is permitted. A licensee is not permitted to file a lawsuit on his own behalf against the third parties. Remember. So, what is the difference or distinction between lease and a license? A lease is right in rem. Right in rems are those rights which are available against the whole world. The rights which are available against the whole world, that are called right in rem. So lease is a right in rem, that is, it is available against the whole world. Whereas a license is right in personam. Right in personam means it is binding only to the parties concerned, not to the whole world. So second, a lease is a transferable right, while a license is non-transferable right. Third, a lease is a heritable. Lease can be heritated. So it is a heritable, while license is not heritable. It is not heritable. A lease is not revocable, but a license is revocable. A lease requires registration as per the Transfer of Property Act, while a grant of license need not to be registered. A lessee can maintain a suit for possession while a licensee cannot. So, another thing, a license comes to an end on the death of the licensee. See here, this is most important. A license comes to an end on the death of the licensee, but such is not in the case of lease. In a lease, the lessee exclusively possesses a property. See here, licensee exclusively possesses the property. But in a license, there is no exclusive possession of the property by the licensee. In case of trespass, whether the property is leased or licensed, a licensee has no right to take an action against the trespasser, while lessee can take such an action. So there is a transfer of interest in the property in case of lease, but while there is no such transfer in case of license. So this is the difference between a leasehold property and a licensed property. And then what are the different types of licenses in real estate? There are three types of licenses in real estate. First one is simple license. So this is most common form of license, where a property owner allows someone to use a property for a specified time or purpose without conferring any right over the property itself. For example, allowing someone to park their car on your property for a monthly fees, which we have already discussed. Then license coupled with an interest. So in some cases, a license may be coupled with an interest, such as when a person is allowed to use a property for the purpose of exercising right or of interest. So, exercising a right or interest. Example, a person is given a license to harvest fruits from a tree standing on another's land. Third one is exclusive license. So, a license that grants licensee exclusive rights over the property for a specific purpose, but still does not transfer the ownership. For example, a business renting a portion of the building for operating a shop, but with a clause that no other person can operate in that location during the period of the agreement. So, what is the role of license in real estate valuation? How it affects? So, whenever you have to do valuation, you must take into account the existence of a license in determining the property value. So, as it may limit the rights of the property owner or restrict certain uses. Since licenses are revocable, they do not add to long-term value of the property, but may impact the rental or short-term value of the property. So, in cases where a property is subject to a license arrangement, a valuer must assess the renewal clause. What you have to see there, whether there is a renewal clause, exclusivity of use, and any other potential risk due to revocation. So, how it impact? First thing, as we have already discussed, short-term uses. So, it is as the lease is generally for long-term uses, it values these licenses are for mostly for short-term uses. So, values must account for transient nature of the license. The value of the property subject to license is generally usually lower than the property under long-term lease agreement. You must remember. Then risks and uncertainty. Why the risk? Because generally in licenses are revocable, so there is a degree of uncertainty attached to the property with the license arrangement. So valuer should adjust the potential loss of income if the license is revoked. And next is non-transferable rights. The rights are not transferable in case of license. So the non-transferability of licenses means that any income derived from the license arrangement cannot be transferred to another person, affecting the property's investment value. So in as when you are doing valuation for IBBA purpose, the IBBA regulations demands precise understanding and accounting for all legal rights and encumbrances on the property being valued, including licenses. So when you are doing valuation, especially for IBBA also, you have to check this. A professional value must ensure that license agreements do not misrepresent the potential earning or uses right of the property. So how the valuation of licensed property is carried out? So as a real estate valuer, you should differentiate. First thing, you should know the difference between lease agreement and licenses while you are doing valuation of some licensed property. For example, a lease may have more stable and predictable rental income, while a license may provide more flexibility but less security because of it is revocable. So if the property is subjected to a license arrangement, the valuer must consider the terms of the license such as revocation, exclusivity, and duration to determine its impact on the property's current value. So now we will be taking some examples that will make the things more clear. A licensed property. Mr. Arun took a residential apartment building in Model Town, Jalandhar on a license in January 2024 for 4 years. The area of the apartment is 3200 square feet. He agreed to pay a license fee at the rate of 2,50,000 per month. He also paid a deposit of rupees 35 lakh. The licensor has to pay an amount of rupees 24,000 per month to the society as maintenance. Calculate the sale value of the apartment in January 2025. The composite sale price of an apartment is 30,000 per square feet. Assume 7% capitalization rate and yield at the rate of 3% for such properties. So, as a licensed property, Rent Act is not applicable. Hence, the property will revert back to the owner after 3 years. So, if the property is sold on January 2025, the prospective buyers have the following two benefits. First, income for another 3 years and reversionary value for the apartment after 3 years. So, gross license fees is 2,50,000 per month. So, gross annual income of the licensor will be 2,50,000 multiplied by 12 rupees 30 lakh. And maintenance charges to 24,000 per month for 12 months, 2,88,000. So net income will be 27,12,000. So of course we will apply YP single rate. So R is here is 0.03 and remaining license period is 3 years. So you calculate YP single rate, its formula is 1 upon R into 1 minus 1 upon 1 plus R raised to power n. You calculate, it comes out to be 2.833. So value comes out to be 2.833 multiplied by 27 lakh 12,000. So value is 76 lakh 83,096. So you can also calculate value with the help of Excel. You put the value in a cell, put equal to PV 3%, comma 3, comma 27 lakh 12,000 net rent, comma 0. So value with the help of Excel will be 76 lakh 71,194. So after 3 years, so property will revert back to the licensor. So value of the apartment with vacant possession will be 3,200 into 30,000, 96 lakh. So it will revert back after 3 years, assuming at the rate of 7% yield. So 96 lakh multiplied by present value factor, you calculate for 7% for 3 years, it is 0.186, 78 lakh 33,600. You can also calculate the present value with the PV 7%, 3 years the remaining period. So, and 96 lakh is the future value, comma 0. So it is 78 lakh 36,460 with the Excel. So, but we are taking the values which we have calculated manually. We add both of them. That will be the total sale value of the property, which is 1 crore 55 lakh 16,696. So we will be taking another example how the value of the land or a property will be affected because of easement. A freehold square open plot with one side as 30 meter is situated at the junction of two 10-meter wide roads. The land is situated in a commanding position, but at one of the corner point on roadside, it contains a well. The owner of 7 adjoining properties have easement right in the form of drawing water from the well. The estimated rate of open land in the locality may be taken as to vary from 15,000 to 16,000 per square meter. Work out the value of the property. Means the property is situated at the junction of two roads, but there is a well at this point from where owner of seven adjoining properties have easement right in the form of drawing water. So, though the value of per unit per square meter is 15,000 to 16,000 per square meter, however, the presence of an easement on the property will considerably affect the market value of the property. Any prudent purchaser would think that he has either to tolerate the easement rights of the owners of the seven adjoining property, or he has to spend considerable amount for extinguishing the said easement rights. So what you can do it here, you can take the value of the property under these circumstances. The rate of the land of the property under consideration may be taken as 50%. So this percentage will depend on your experience and the conditions at site you have to check. So there you have to reduce the value. We are in this case we are reducing the value by 50%. So we will assume that after 16,000 prevailing rate is 8,000 per square meter. So area of the land 30 meter by 30 meter 900 square meter, and the value of the land 900 square meter into 8,000 square meter per square meter 7 crore 20 lakh. So instead of otherwise its value would have been 14 crore 40 lakh. So see here how it affects the value of the property, a license or easement. So this is all about valuation of licensed properties under Easement Act 1882. Thank you, friends. Have a nice day. So please like, share, and subscribe our YouTube channel for more educational videos on valuation and other related videos. Of course, all these videos are free of cost. And if you have any suggestion, please comment your suggestions in the comment box. Your suggestions are always welcome. Thank you, friends. Have a nice day.